The co-defendants in one of the most high-profile murder cases in Idaho history appeared in a Fremont County courtroom today. Both Lori and Chad Daybell appearing in front of Judge Stephen Boyce to argue several motions ahead of their trial set to start in Ada County on April 3rd. As we've reported, cameras are no longer allowed inside the courtroom for hearings in the case, but Nate Eaton from our partners at East Idaho News was there today and joins us now with some of the latest developments. So Nate, you've been to a majority of these hearings in person. Was there anything that stood out to you today or surprised you at all?
You know, this was a pretty procedural type of hearing. What I immediately noticed is that Chad and Lori Daybell were both in ankle shackles. That is something we haven't seen over here in Fremont County. I understand they might do that in Ada County, but that was a little different as far as just a casual observation. The big issue today, one of the big issues today, was Lori Daybell's defense attorney arguing that her case should be dismissed because they argue that her constitutional rights are being violated because she has not had a speedy trial. She hasn't waived that speedy trial yet. She doesn't plan to waive it. And you have 6 months in Idaho from the date you're arraigned to go to trial. And I believe when her trial starts, it's something like 44 days over that time period. So her attorneys argued to the judge that her case should legally be dismissed. The prosecution responded and said, listen, there's been reasons for the dismissal. One, we have to move the case to Boise. And two, there's been competency issues with her particular case. And so the judge said he would take that under advisement and issue a written order. I really don't foresee him dropping the case, dismissing it. If he did, then the prosecution could refile the charges if they felt that was necessary.
All right. And there was also, a bit of discussion related to jury selection today and asking individuals about their religion. So a few questions here. What was the purpose behind that topic? What was decided? And as far as we know, are both of these defendants going to have the same jurors?
Yeah, good question. So the separate motions were filed regarding the jury. One was that when they call this jury together, potential jurors, that they're allowed to have individual examinations of each of them if needed. And as part of that examinations, they could ask more sensitive questions like, do you have a history of spousal abuse? Or what are your religious beliefs? And the defense, Lori's defense attorneys argued that religion will be a key part of this case, particularly the LDS religion. Prosecutors pushed back and said, we don't mind the individual meetups, but we object to asking jurors their religious affiliation. You can't disqualify a jury because they happen to be LDS or a juror. And so the judge, as far as that issue, said, yes, you can do individual one-on-ones, but what the plan is now is to do small groups, interview them all kind of as a group, and then if the need is, you can meet with them one-on-one. The second issue with the jury is that there will be some pre-selected instructions that all parties agree on, the judge, the prosecution, the defense, before the jury's even picked, the jurors are picked, they will be given specific instructions as to what to consider, as far as the questions, things like that. So it was just kind of a consensus among that group. As far as if there will be separate juries, as of now, it will be all one jury hearing both cases unless the judge decides to sever the cases, then obviously you'd have two separate trials with two different juries.
And are we still waiting on a ruling from Judge Boyce related to Lori Vallow's request to take the death penalty off the table? And did that come up at all today?
That did not come up today, and the judge has not issued a formal ruling on that. So that's yet to be determined.
Okay, and we also know Chad's attorney, John Pryor, has repeatedly made arguments to separate his client's trial from his wife's. We know that discussion, which was brought up today, was also continued now to be discussed at their next hearing on February 23rd. What else do we expect to see discussed at that hearing, and is there anything else that you're anticipating to see before then?
The big thing I think that will happen at the next hearing is Chad's attorney is going to argue that he is still waiting on evidence. Both sides are still waiting on DNA evidence. And this trial is 6 weeks away. And that if they get that DNA evidence in 2 weeks, that only gives his expert 4 weeks to test it and report on it and analyze it. And sometimes these things can take a long time. So he's going to argue, as he brought up today, he just recently got 1,100 pages of documents he had not seen, GPS reports that he had not seen that take time. He's going to argue that, Judge, I need more time to analyze this, to give my a defendant a right to a fair trial. The tricky thing is Lori has not waived that right, as we just talked about, so they're tied together. So he could have a strong argument in the next hearing when that will be discussed. There'll be a few other motions filed that will be brought up at that discussion. Between now and then, as of now, there's nothing officially on the record. There could be anything could happen, really, as far as if they suddenly decide to enter a plea agreement or they go into mediation and talk a settlement. That is anticipated to happen between now and the trial start date, and that could, change everything once again.
Yes, a lot of moving parts here that we appreciate you following so closely for several years now. So Nate Eaton with East Idaho News, thank you so much for joining us again.
Thanks, Karen.
And of course, you can read Nate's full article all about today's hearing and the details on eastidahonews.com.